is item 4C, and this is legislative also, and it's an ordinance of Vero Beach, Florida, amending the code of the City of Vero Beach, Chapter 72, Traffic and Vehicle, Article 2, Division 3, Residential Restrictions by creating Section 7482D, providing for restrictions on the parking of motor vehicles in front yards in residential zones districts except on an authorized or permitted improved surface, providing for conflict and severability, providing for an effective date. And Tim, I'll let you
thank you.
That.
I think we've gotten into some of the issues that we talked about was the parking on lawns and on places. And there are a lot of neighborhood issues with this. It's unsightly. It also causes problems when people are tracking dirt into the streets because they've been on wet lawns and all that. But I think basically the quality of life issue is probably the major thing that the people, that the complaints, and that certainly was one of the complaints about on boarding houses. But we also have this issue going on in other neighborhoods where we get people complaining. They say, well, isn't it against every place I ever lived? It's not, you can't do that. Well, our ordinance doesn't have that. As I pointed out, the county has an ordinance that you can't park in the front yard setback, and they limit the cars. So, what we're proposing here would be to restrict parking in the front yard if it isn't on an improved surface or one that's been approved by the planning department. Oh, go ahead. I'm sorry.
I have a question. What constitutes the front yard setback?
That's generally 25 feet measured from the right-of-way line.
Well,
in the code.
The reason I ask is this. I have in mind the house that I lived in, and my daughter and son-in-law are now living in it, and it's been the site of family holiday gatherings and stuff like that for years and years and years. Now, the hard surface parking area will hold, outside of the garage, will hold 4 cars.
Okay.
All right. Now, other cars, we usually wind up parking in the swale, which is really, it's grass. It's a grass, but it's
probably in the right of way.
Well, actually, you're not supposed to park in the right of way because it's a 2-lane street, so it's a paved surface.
Unless it's posted.
Yeah,
right?
Unless it's posted, no parking.
In fact, yes.
Okay. Let me just put it. It's common practice not to do that in that neighborhood.
Okay.
And so the swale, which I'm referring to, the swale is actually part of the front yard in the sense that it's all grassed. But you're off the paved surface. Okay, is that actually part of the setback?
No, the setback starts where your right of way, your property line is. So the swale is
wait a minute, where the property line is.
Right. It goes back 25 feet from your property line.
25 feet from the property line. Okay,
right.
I guess we're safe then. I have a vision of.
Right. I mean, yes. And in fact, if you go in Central Beach, like or some of these roads like Dahlia and all that, you'll see the sidewalk back and it's grass and people park there.
Yeah,
and that certainly
because there's no sidewalk.
Right.
And the reason I was asking was because the original draft had occasional exceptions in it, which I felt warm inside about for that reason.
Well, I guess
that's been eliminated. So I want to make sure I stay legal when I go to my.
Well, what we did is took it out because we thought it just needlessly, created problems in interpreting the ordinance. And the other thing is, to be honest with you, this isn't the kind of thing the code people are going to be out looking for people parking in grass. It's going to be more complaint driven, or there's some obvious problems, and it gives us that. But I mean, certainly it's not going to be a priority for the staff to be out looking for this, but it does where people are routinely doing this, we'll get a complaint and we can deal with it. So we try to give some flexibility.
I think if we're talking 25 feet from the property line itself, I think we're okay.
Right.
Good. Thank you.
So you're saying you can park in the right of way, but
no, go ahead. I'm sorry.
Before we go too far, do we want to open up to the public, or do you want to have?
Well, I mean, I'll answer your questions, and then you can open up to the public.
I think let's let Tim proceed, and then we'll ask.
Well, there's not a lot.
There's not a lot.
The only thing I was going to add, remember, in my house as an example, I'm 50 feet back from the property line, but. So I just couldn't park in the first 25.
That's right. If you got a deep lot,
I've got 24 foot of right of way. Some ordinance, they actually just say from the front line of the house to the front property line, no parking.
That's pretty restrictive.
Yeah.
Right.
So if you have more than the required front yard under this, you could theoretically park up next to your house and not violate it.
Right.
So,
and we do have some of that, depending on.
Yeah, why would we allow, in Wayne's case, why would we allow parking in the front yard, even though it's 25 foot back from the property line?
Well, I think the point is we allow that for trailers and stuff. I mean, it goes with the code, and plus you get a larger yard, the impact on the neighborhood is less if they're further back off the road. I mean, let's face it. If they're
After you're 25 feet back, who are you bothering?
Yeah, and you got more open space because it's vacant.
Bigger
but
yard.
If you're all jammed in there and there's the building, it definitely has more of an impact, at least visually.
You got a trailer or a motor home or something on your grass in front of your
any motor vehicle.
I don't understand.
Yeah, it's this way the code is written. Most of the restrictions say just can't do this in the front yard, can't do this in the front yard. You know, that gives you whatever your setback is, and I don't know if it's pretty consistent.
It's around 25 feet,
feet.
Yeah, in the residential areas. Yeah.
You remove the temporarily parked to be washed or social gatherings.
Right. I mean, if somebody's washing their car, it's not going to be. The violation will be gone before somebody shows up out there. You know. So we just, as I said, this is going to be mostly where we get a complaint where there's obviously a problem going on, a chronic problem, then we'll deal with it.
Yeah, and the water perks into the grass, and it's better than putting on street.
The same cause of park there for.
Right.
But you can park in the right of way. You just can't park on your own property.
That's correct, except on an improved surface. Okay, so I mean, if somebody wants to have more cars on there, they'll have to come in and get approval if they don't already have it.
There's a couple of lots I've seen where they took up the grass and and the entire yard is gravel. They could park anywhere, I guess, right?
Well, they also then they get into storm drainage issues too. I mean, that would be looked at. So they got open some other things that come into play. So it's not automatic depending on the size of your lot. That's true.
You can't automatically make your driveway big enough to accommodate anything.
No, that won't necessarily happen.
You run into other problems.
The one thing I want to point out, I was going to add in the amendment, on the last sentence, the front yard setback should be defined, specified by the zoning district I think we need to add Part 3, Title 6. Part 3 is I didn't put that in there. And why I put these references in there, because this section of the code is not back in the land development
Would you
regulations.
repeat that? I didn't catch you yet.
Oh, it's on
page 2 or 3?
Yeah, look at 2 or 3.
Yeah.
The D, the last sentence, where it says the front yard setback should be defined and specified by zoning district in Part 3. And why do the front yard that way? In Part 3 is before Title 6. And why you do that, because if you have a corner lot, that's 2 front yards. And see, you wouldn't pick that up. We're not defining. I want to be sure it's linked in with the land development regulations. That's the only reason we do it here, because it's not in the land development.
Okay, I understand.
It's just and somebody will want to know, and why can't I do this?
With that discussion, I'm going to open up to the public. Would anybody like to speak in reference to this? Please come forward.
Again, Linda Hillman, 2315 18th Avenue. One of the big issues that was not mentioned by Mr. McGarry with parking on front laws is the destruction of the sidewalks and also of the curbs. In original town, most of our sidewalks and curbs are original. We have had since a lot of them replaced because of situations like this. That home on 16th Avenue that I've talked about, they are constantly going over the sidewalk and the curbs onto the front lawn and parking under the tree area. We have a rental on 18th Avenue right now that has a lawn business being run out of it. We've complained about it. That was taken care of, but we're right back in again where we have several trucks with trailers pulling over the curb onto the right-of-way to park in front while they're waiting for their instructions on where to go to work. The daycare center that's on the corner of 24th Street and 18th Avenue, the people who work there, Tim has walked the neighborhood with me and has seen the workers parking their vehicles right under where there's a tree so they're not in the sun. There's a huge parking lot, but it's in the sun. They don't want to park in the sun, so they pull their vehicles up over the sidewalks, over the curbs, and they park under a tree. That has to be stopped. There has to be a regulation about that. We're paying good taxpayer money to repair all of this, and there has to be a regulation that's going to prevent that, not just the fact that it's unsightly. So this is very big issues, when it comes to how we're tightening our budget in this city. This has to be included in part of it because they are destroying our property. Thank you.
Thank you, Linda.
And the provision,
Any questions?
and the provision is all there for the enforcement on this regulation. And
Oh, yes. Oh, I just want to point out, I'm surprised nobody pointed it out. If you look under Section 2 on page 2, I'd say Section -38 is hereby amended. I think I meant 82, 7482. I had the wrong number. Yeah, okay. So I clarify that. The other thing Wayne just pointed out to me, we think there may be some obscure place in the code that allows you to point on the lawn or park on the lawn. We're going to do a search. We'll have to repeal that. I don't recall running across that, but Wayne thinks there is maybe something. So we'll have to take a look at that and repeal it.
This proposed ordinance is relative to residential single-family detached properties only. Is that correct?
No, this is all in residential districts.
Residential districts?
Yeah, the definition in that up front is, what do they say? What do they say for the definition?
Residential restriction for creating in front yard setbacks in residential zoning districts.
Oh, here we go.
Does that include multifamily then?
Residential districts.
I would suppose.
Yeah,
Even multifamily.
yeah, it's
It would
all
not-
the
or would it-
districts.
Wayne, you're saying it would apply to multifamily as well?
Yes, it's all residential districts.
impervious
Okay.
surface.
Okay.
How do you
So-
handle parking on sidewalks?
That's what I was looking for that.
Oh, well, that's not legal.
Right.
To begin with,
Yeah,
That's in the right of way.
but you cannot park on a sidewalk.
Sidewalk,
That
yeah.
might be where it is, right away.
Yeah, you're not allowed to park on a sidewalk in the right of way.
That's supposed to be blocking the sidewalk.
Well, yeah. I mean, we have had code enforcement on that. But that was a good point that in some of these lots where you don't have room to get on the property, people will go over the curbs and do that and will cause damage. And it's something we don't like to see.
Wayne, I found it. It's off-site parking facilities, and it's parking in yard areas, except for required landscape and buffer areas, and as may be restricted elsewhere in this title in part. Side yard, rear, and front yard areas may be used for required off-street parking areas.
Yeah. What's that number, Peggy?
I'm looking for it.
Where is that?
I got to go back up. 62.02.
It's back in zoning.
Yeah, required off-street parking and loading/unloading.
That's what I thought.
Well, that sounds non-residential, though.
Yeah, I'm not sure where I am because I'm in a.
I've got to look at it.
I'm not, whatever you're referring to right now, I'm out of the loop here. I don't.
Oh, we're just looking at the code.
Oh, okay.
Yeah, you don't
This
don't have
obscure
that.
area where they allow the
It's chapter
parking.
63.
63.
So if you are landscaping
it?
or something, you can park there?
But isn't that non-residential?
Is there a
There's non-residential lectures and things we do allow.
No, that's just
Yeah.
the general off-street parking and loading
Yeah.
requirements.
Is that what you were thinking about?
Yeah, that's
Yeah.
it.
So that doesn't impact this.
It's down at K.
Okay. Parking in yard areas for.
Yeah, we'll need to repeal that.
We're gonna.
Yeah,
I think
that's-
we'll have to
that's an
deal with it.
issue.
Very
Yeah.
good. I'm glad we.
Is it worth identifying to us or not?
Yes. It would.
Sure, it's 63.02
Okay.
K.
And what are we going to repeal?
Off-site parking and loading zones sound commercial or certainly non-residential to me. Is it?
Well, no, you've got off-street parking for single family too. Like they have to have two. Okay.
Oh, okay.
So we'll have to take a look at that, amend it probably. The whole thing is probably some of it's okay. We're just going to have to
Can we
amend
pass this and then you would have to repeal that part, or
We'll do it at the same time. We'll put something together.
so you'll
to do that.
bring this back to us? Or
If you want us to come back,
It's simple.
If there's
it's a simple change. We just
Yeah.
want to
So if
make
there's a motion, do we need to mention that in the motion?
yeah, I would go
Would
ahead.
be good.
Right.
Because you're just
Well, you're
moving
still on a public
to
hearing.
Yeah.
take it to city council.
Yeah.
Oh,
Yeah.
You're
And
recommending
close
it to
that.
city council with some
Right.
changes.
What? Oh, we're still on a public hearing. Okay. We better close the public hearing. We don't see anybody else who would like to speak. Is that correct? And we're closing the public hearing.
Mr. Chairman, does anybody else feel like I do that in the case that Wayne brought up, we shouldn't be parking in the front yard, even if it's 26 foot back from the property line?
I'm going to make a different kind of comment back to you. I've been here in Vero Beach now, I think 12 years, and I think this whole issue comes to me a little differently. It depends where you live at in the city as to what is acceptable to the neighborhood. And if where I live at, if I parked my car in the front yard, I would be chastised. If I was someplace else in the city and I parked my car in the front yard, I would be equal with everybody else in the neighborhood because everybody's parking their car in the front yard, and including their boats and their skidoos and everything else that they have. So I think that when and if we consider passing this, that the revolt may come slowly when the implementation comes on, because I think there's a lot of people that have a small boat and have a car, and they have and husband and wife have a car and they have a small boat, and now we're going to make it very difficult because they have a chain link fence to the side of their house.
They can't put a boat and trailer in the front yard anyway. We're routinely
Okay, but my
going-
point being, I'm going with this. This is acceptable practice some places here, and we are changing the neighborhood norm.
and that's true.
And,
mean,
I just
that's-
know that there's a consequence to that, and I think it would be positive, but
what's the consequence?
I think that there'll be a lot of people that will be upset about it, and if we try to enforce it, I think it'll.
Well, it's an enforcement thing. But again, it's going to be by complaint.
By complaint, I
assume.
guess that's.
It's generally going to be by complaint. We're not going to go making it.
But my point is that according to this, Wayne can park his car or truck or trailer or mobile home, motor home, smack in the middle of his front yard
25 feet or more
because
behind
it's
them.
25 feet behind
well,
the property
they
line.
can do that now. I mean, with their
I know, but
watercraft.
if we pass this and modify it to the whole front yard as opposed to some part of the front yard, then you can't.
Well, that's true, but that's more draconian than what we've been proposed here. I
Well,
think.
let
And
me
plus
let me talk to you this. There's one house I know of in Original Town where the individual put their home at the very close to the alley, and as a matter of fact, out the back door to the alley, there's only like 8 feet, maybe 6, and it was done prior to. The side yards are very restrictive, but the front yard maybe is 125 feet back.
Right.
Where do they park their boat?
Well, they can. I think on our code, as long as it's more than 25 feet back from
But
the.
my point, if he's trying to get it to make it to the front of the house, there is no.
Oh, I
place to
know.
put the
No,
boat. And that's the kind of person I'm thinking about.
Yes.
Didn't you just say you can't park the boat in the front yard?
No,
Period.
the 25 within the required front yard is 25 feet. So when you have large, for instance,
So
we
we're making this the same as the boat.
except that you can park a car on an improved surface like you can now. I mean, the ordinance, as long as it's improved surface that's approved, you can. Somebody. No, I don't have a.
Sounds like it's down there somewhere.
Oh, anyway. Whew. No, as long as it's on an improved or an approved surface, it can be parked there.
Someone have a phone near the microphones?
That's the problem. I don't have a phone.
I don't.
Really, really strong. It's wiping out the audio. Somebody's phone is.
Somebody's cell phone.
Mine's off, I think.
It's
Next
those
to the mic-
reporters.
Can we finally have the bailiff remove somebody? I apologize. I was just teasing. They are disruptive in the media.
I know.
What we're dealing with exclusively here is residential areas, and we're talking about improved surfaces.
Correct.
Yeah, front yard. I have no problem with that.
And I mean, there's the ability ability of people to get, come in if they need some more room to do that, if they have the room. It's not an automatic. So
Mark's point, though, we haven't addressed, I don't think, what you comment. You want to take it to the front of the home as opposed to just 25 feet back. Is that correct? Is that what you're talking about?
Under this ordinance, I could park my car in front of my front door because it's not
Improved surface.
No, on the grass. Because it's
This
more than
ordinance says
25
improved.
feet from the property line.
But we're referencing an improved surface.
Well, anybody can park on any improved surface.
well,
But this is grass.
yeah, I mean, what we were saying, that the visual impacts and everything on the neighborhood are a lot less when it's back that far. But you're right. I mean, and if we come up with what Mr. Lawfer just put out, there would be these
Or a
circumstances
circular driveway. A circular driveway
Yeah.
is another thing. You have a circular driveway, and you would park right in front of your house because you come in right in front of the door, you get out where your guest would come. So in that case,
circular driveway,
That's
you
on a
can
hard
park
surface, though.
you can
Yeah.
park all over.
That's fine,
hard
but
surface.
That's not parking on the
Yeah.
grass.
hard surface
Sure.
there. Okay. I don't know, Mark, whether
I don't know. Again, that's better than nothing.
if that's all we're doing, we ought to just go home, maybe. But,
So moved.
I think that. I think this ordinance has merit. I believe in most cases it'll be a positive improvement. Now, does it come into my philosophy of individual land rights again? I question that.
Well, I think it's good too. I'm just having a problem between the area that's 25 foot from the property line and the home. That's fair game for parking on the grass.
Not grass, because we're talking about an improved surface.
No, that's not my understanding.
Yes. Yes?
Can
No?
we get a ruling?
I thought I'm.
It could
It could be
for
grass,
an
but it's
improved
beyond the
surface. It could be
25
grass for an
feet. You're
improved
correct.
surface.
On a designated driveway or other improved surface.
But that's in the required front yard. So if you have a house back more, the 25, and you got room, you could put it on the lawn.
Which,
But I mean,
really, you're getting. I think what we're seeing in this ordinance is what is generally accepted by most people is what you should do if you live in a single-family residential area. And I don't think it's going to surprise. I think most people would be surprised if they knew. They'd think the ordinance is already there, and we just don't have one. What I think it amounts to,
I
in
can
my
tell
opinion.
you, I get a lot of calls that people think.
And they would already have this there.
That's right.
And we don't live in a community that has gates on it and covenants and restrictions. So this is a way of providing some security so that we don't get neighbors parking vehicles inappropriately on their individual properties. And
I think parking my car in front of my front door is inappropriate on the grass.
Okay, then you won't do it, right?
Then you either you're voting for it or you're going to motion.
Well, I'm asking for a discussion on amendment.
I don't think we want to go too far with it. That's my point. I think that where it is right now is acceptable. If we find that everybody's parking their car close to their house on the grass, then we might have to address.
I think we're going to see. I mean, I had some problems with this because I was concerned that we do have people doing this that it impacts everybody in the thing. But I think it's a reasonable way to go. If we, we'll find out when we're running up the flagpole through the process. And to go further than that right now, I think would be more unreasonable, and we would get more opposition on this, and we wouldn't get what we're looking for.
I can also put probably 8 cars in my right on the grass in the front yard.
Well, I use it.
Good.
But I do.
Well, our next party is going to be Mark's house.
They park on the right of way, and all my neighbors that have parties or whatever, they park in the right of way. There's no problem with that. I don't see an issue there.
It brought
if they
it to
parked
light.
every day there, I wouldn't even care.
Yeah, and remember, in Peggy's point, I brought this to light. We brought this up is because of the boarding house issue. One of the impacts of boarding houses. That's why I make the comment. We're really going to be responding to complaints where this happens.
And short term and vacation.
Right.
Yeah.
all those things. It's when you're jamming up the
Well, that's true.
occupancy of the home. Right?
Yes.
And if I have a chance to park my car in the driveway or my anything in the driveway as opposed to on the grass, most times at 9 out of 10 I'd park in the driveway. It's only when you have extra company or guests you may pull the car onto the grass, or you want to wash it so the water doesn't go on the
Temporary,
street.
yeah.
So most times it's you don't want to tear up your lawn. Why would anybody want to tear up their own lawn? If you stay on the driveway, you don't do that. That's why we have them. So I'm in favor of this.
And quite frankly, when this issue of boarding houses was raised to me, I said, well, what is it really that's the problem? Parking on the lawn is what was mentioned.
What if the boarding house has more than 25 foot of front yard?
That's true.
Then
Then they can park
They'll be okay.
unlimited number of vehicles on the grass in the front yard. I'll vote for this, but that's my point.
And if you think that we start at those exceptions or exemptions for temporarily for washing, you could do it for unloading or loading, family gatherings. We're trying to limit it to a certain number of year. I mean, who's going to keep track of that? You know. Then we started talking. Well, when's most of this stuff happen? On the weekend. Well, guess what? Code enforcement doesn't work on the weekend. So, like Tim said, by the time you respond to the complaint, it's corrected itself.
Tim at home. I'm sorry, Tim. I shouldn't have given out your phone number either.
I've seen Tim pull signs on the weekends.
And you were helping.
Is there any
right?
further discussion by the board here? Then I'm looking for a motion.
Move to approve.
Do I have a second?
So moved.
Is there any further discussion? We have a first and a second. Is there any additional discussion?
Let me just clarify this thing again, Wayne. On the page 2 of your introduction, going down to the paragraph that starts the storage or parking of water. Oh, no. Yeah, the second sentence there. The proposed ordinance only restricts motor vehicles in front yard setbacks if they are not located on a designated driveway or other improved surface. So that is saying you can.
No, it's restricting them if they're not.
Only restricts them in the setbacks if they're not on a driveway. I guess this isn't getting through to me.
Well, hopefully that may not be, but hopefully the language in the code, in the amendment is a...
So that agrees?
Yes. It may not have been worded properly, but...
I think that's where I'm having difficulty here, Tim.
No,
A little wordsmithing would help.
Yeah.
Okay.
We don't have to change the cover letter if it's clear in the ordinance.
Before it goes to
No, I will.
Go to
Before it goes to
ordinance.
council, I'll be reviewing it. I usually do that, and I'll pick up the sloppy grammar and all the other things if Wayne doesn't do it for me.
So there is no parking. So there is no parking on the setbacks.
Yeah, there's no parking setback except on improved
Surfaces. Yeah.
Correct.
Okay.
You're okay?
Yeah, fine with that.
Any additional discussion? I'm going to call the question. All in favor, say aye.
Aye.
Oppose? It's unanimous.
All right. Oh, it's getting late here.
I think our next agenda is from our city attorney. And Peggy, you're going to lead this discussion?
Yes, I will, unless Tim wants to start
No,
off.
Peggy, just...
Of course, I'd like to have Tim
I
do
hope
it.
you all don't mind me giving you some case law or discussion of case law, but this was just such an amazing situation where the U.S. Supreme Court reversed the Florida Supreme Court on a land use decision. I thought you might want to know. And if you like this, I have lots of case law I look at every week that I would just love to provide you copies of. But this one was particularly interesting, so I thought I might want to go over it with you. And the experts, of course, are still kind of pawing through it. And Wayne and I both go to a seminar next week for municipal attorneys where I'm sure this will be discussed. And if I find out anything more, I'll bring it back to you. But while I was reading it in the dead week of the 4th of July when I was alone in the office, I thought, well, as long as I'm looking at it, I might as well do a little encapsulation for you all as well as our planning board. I know you read my memo, but let me just go over the facts really briefly. Mr. Kuntz owned 14.9 acres of Florida wetlands property, and he wanted to develop 3.7 acres of the property. He applied to the St. John's Water Management District for the 2 required permits for draining and developing the wetlands property, which are required under Florida statute, which is listed in my memo and in the case. The district refused to approve the project unless he spent money to improve district public lands that were located several miles away. And this government condition that they were trying to impose on Mr. Kuntz was in addition to requiring him, and he was okay with this, to provide a conservation easement over 3/4 of his property, which seemed like quite a bit to me. The Florida Supreme Court held that since there wasn't any burden on a real property interest by the payment of money for this extra condition, Mr. Kuntz had no case. And that's what went to the U.S. Supreme Court, and the U.S. Supreme Court reversed that. So it has changed Florida land use law to a great extent, and Tim can probably talk more about that. But basically, before this ruling, before the U.S. Supreme Court ruling, when a government approves a land use permit with a condition that the property owner actually give up some real property interest, like an easement, like the conservation easement that he was agreeable to, the local government had to show that there was a rational nexus for giving up the property right and a kind of proportionality between the impact of the project and the benefit to the community. So you had to actually be rational and reasonable about this, which is, I think, what we do here. But these tests weren't required for cash mitigation, only for conditions involving real property being relinquished. So that's what the U.S. Supreme Court changed, and it's a big change. And I think let me see if I've got the case here, because when I got to this portion of the case, I knew which way it was going to go. This is the majority speaking. Extortionate demands for property in the land use permitting context run afoul of the taking clause, not because they take property, but because they impermissibly burden the right not to have property taken without just compensation. Nor does it matter that the district might have been able to deny Kuntz's application outright without giving him the option of securing a permit by agreeing to spend money improving public lands. So the court just found that this was a bit of overreaching by the district, and I think that's probably why they held the way they did. And Tim might want to mention how that might impact us here, but I feel like we do that Kuntz analysis every time we ask for a monetary exaction, and looking at your tree ordinance today is a really good example of that.
I could argue that if this is wetlands and it wouldn't ordinarily be buildable, and they're allowing them to build it on the 3 acres, in other words, fill and reduce the wetlands, then giving up the rest of it to conservation is really not mitigation, because it's just status quo. So the mitigation would be the offsite improvement.
I think there was a portion of the land that was wetlands and a portion of the land that wasn't. So it wasn't all wetlands.
I thought you started out by saying it was all wetlands.
I'm sorry.
And wetlands have value, too. I can tell you this. We dealt with it in Keys, so there is value to wetlands. So it is, that comes into the equation.
For more than mitigation?
You have to there has to be a nexus between it. So, I mean, it's a value.
Also, it can be used for density sometimes also.
And it can be. That's true.
But basically, you just have to be reasonable when you're imposing conditions.
Yeah. We proved today that we're more than reasonable.
Absolutely.
Well, and I think that we're about to get into that discussion here, talk about the tree mitigation, as being reasonable about that. And okay.
But paying money to improve district lands that were several miles away from the property itself, you got to wonder.
Are you saying that that's the functional equivalent of paying money for tree mitigation?
No, absolutely not. I mean, there is a rational nexus, and Tim has done analysis that shows that the amount that's being asked for is has a rational nexus with what the purpose is, which is to benefit the public by having more trees and replacing the trees and having a tree fund that goes in that direction. So it's a really good example of the Kuntz decision at work and the Nolan test being applied, the rough proportionality and rational nexus test. So,
at some point in time, when the the law requires you to put more value in than possibly the property's worth or something to be able to utilize your. Are they are they considered taking of the property there, and therefore you should be compensated for it?
And what do you mean by that? The government's
if you're required to mitigate or to give up something for the public benefit to be able to work your property. At some point when you give up so much, the government said after you give up so much, they've taken your property from you. Is that right? And it's unreasonable.
Absolutely right. Yeah,
So
and this is a taking
for example,
case.
charging a building permit, if we went to a building permit and said you have to pay $20,000 for a building permit, in some cases it's more valuable. Are we taking of the property because they couldn't build a home on the property? That's an extreme example.
If you've taken every bit of property that they can build on, that's definitely a taking. There's no question there. But there's just compensation levels below that, and this is a taking case. That monetary exaction was considered to be a taking by the government,
And therefore he should be compensated.
Right, and this is just the first time that a taking analysis has been done on a money exaction.
Right.
So it's a big change in Florida law and law around the country because this is the U.S.
No, I
Supreme
agree.
Court.
Does that fall under Bert Harris?
Pardon?
Does that fall under Bert Harris?
No, but that's interesting. I have another really interesting Bert Harris case that just came down called Ponce de Leon. Is that right, Tim? And I wanted to give it to you, but I didn't want to overload you with too much. So maybe I'll give you that
I'd
next
love to
time.
see that.
Because
Yeah,
it's
if
a
you
very
like, I think these are good for you to hear
It
this.
puts
right?
us in perspective of what we should.
Yeah.
Oh, sure.
At some point we
Okay.
don't want to go.
I run across a lot of interesting land use case law that I'd love to provide you with.
Do we get
It's
continuing
changing, isn't it?
education credit?
Yes, you will. We'll vouch that. I'll have Peggy sign off on your
Probably needed by
CEU.
all of us.
The other thing I found very interesting was that the majority was careful to point out that user fees and taxes are not takings.
That's right. Yeah.
So user fees are where are we with impact fees as far as that's concerned?
Correct.
That's still a fee? Not
Oh, it's-
impacted?
well, yeah,
Not
impact
part of
fee-
it?
Regulatory fee.
Right. It's one that is directly related. They have to show the nexus there for an impact fee.
Okay, so that's not
Yeah.
affected
So
here at all.
and that's why when, say, the county does its concurrency, when it's doing its impact fees, it hires a consultant. They do these detailed studies to show the relationship between development and the need for the
That's the
infrastructure,
nexus. Yeah.
and that's the nexus.
And that's what you've done on the tree ordinance. You've
Well,
shown,
probably not that kind of deep, but you're
well,
right. And a lot of it is we're balancing it as we discussed it
Right.
at the meeting or at these sessions. So I had one other thing I'd like to add under the planning director with the cutbacks in the staffing that are occurring in the city. We're probably after October 1, we're requesting that we probably only meet once a month unless we have to. This would the burden on the clerical staff and everybody else. It's just the fewer people you have, the more people have to cover for other things.
Is that
So-
going to slow down any of this?
No, we will not.
process?
Anybody has an application stuff come through, we'll call a meeting. We have to, but it won't be till after October before we go to once a month meetings. If we have to have more, we'll call them. We just won't.
Wow.
Well.
I object. I so love coming here and spending the whole
And I would miss not seeing you twice a month.
It's getting very deep into the subject.
I didn't need to know that.
I said into the subject.
Okay, Mr. Chairman, that's all I have.
All right, sir. Thank you, Peggy. Are there any board member matters?
Yeah, I just wanted to follow up on some information that had been in our minutes the last time. The follow-up with the Real Estate Commission regarding the realtors advertising these vacation rentals. Any response from them? Or
No, we send out the agenda and all that, but to be honest with you, we have not sent out any. I mean, you're getting into an area that, it's a little troublesome. You have a right to advertise and do that. But we haven't done anything directly. No, we haven't.
I think she was talking about the ethical question.
Yeah, well, it was to the Florida Real Estate
Right.
Commission, not the locals. Yeah.
Well, we have made complaints to them about where we've gotten. For instance, we did a complaint to them, to the Florida Real Estate. We did it on one, and they have changed their advertising and all that. So we that is one that I forgot to mention that we are doing that. So
Okay.
they'll do the investigation. It certainly has changed. We had one broker that had 5 or 6, and he's changed his ads.
So you're finding support on the state level? for
Well,
this?
enough to get them to come in. Whether we're having a support at the state level, I get back to it. Who do you think changed the code? The Florida statutes.
But did he change the advertising to get around?
The preemption. Pardon?
Did he change the advertising to get around something?
Well, no,
Or
he was
did
told he couldn't
it's
do
now
that.
Acceptable?
But let's put it this way: we keep those properties under. We monitor on those properties. I mean, once it comes to our attention, we do monitor them to see any complaints on that. Okay, so it isn't like we forget about them. I said a lot of these cases, they may come into compliance, but we continue to monitor them just because we've had.
Well, that was my
past
question.
history.
You can change the ad, and it's still maybe not in compliance.
Right, but we
or
have
you're
not
still
found
maybe
them.
happy with it.
But we need to find them in violation, and that means either a neighbor has to tell us, or we're checking on it, and we come across, say, out-of-state license plates that are obvious. So we'll run the tags to see where they're from and do that kind of thing, or even in-state ones. We'll run the tags. But then again, we don't have a violation until we have more information. So we have to monitor it. So that gets us into. So once you've gone to a point where we have enough information, we have people on site, we will go to the door and ask them, and tell them, look, we do get people nervous, and ask them, oh, we're here for a week and doing that. So okay, and then we send out a warning on the first time for that.
Okay, so with what you're telling us now, once a month starting October, are you going to prioritize your
Well, no, I'm going to
work
continue to
program?
work where we can on this thing. For instance, Linda was here, Linda Hillman.
Right.
She's still got to get back to. We've had the meeting with her over the draft comprehensive plan element for her neighborhood, but she wants to get her neighborhood group together before they
That
want to
makes
have a
sense.
meeting with
Yeah.
you all, and
Get
we'll call
organized.
it when that time comes. We'll have a meeting. They want to be organized. I think the concern she has, she doesn't want to appear like it's just 3 people representing the neighborhood.
Sure.
She wants to come forward that she represents the neighborhood, or her group does,
I've been
and
here
that's one of her
before.
things. She's,
I think
which I
that's-
think we all want.
It's
that.
essential to success.
Correct.
Yeah.
To get that kind of commitment, and so she's doing her due diligence on this. Okay.
Sure. And then you mentioned annexation. You'll be talking about that soon?
Right. You're going to have a report probably at your. It won't be the first. It'll be the 15th. I can't remember. It'll be in August. We have one of the requirements of the code that we do an annexation. Not the code. Our policies is an annexation report. It's been completed. My boss has signed off on the city manager, and we held up on it because the applicant asked us to until they're on vacation. So once they're ready, we're going to go forward, and you will see the report to make a recommendation to the city council.
I'm on the edge of my seat to find out why anyone would want to.
No, I told you it's my understanding is mostly the flexible. Our parking standards are more flexible in the counties.
Oh.
That was one reason they wanted to do it. Maybe some other.
Any other board members have any questions of Tim or items they want to bring up? If not, or I'm looking for an adjournment.
You got one.
Okay, we have an adjournment. Thank you.